What happens when a pair of pants sues for $54 million? Or when a man takes God to court and the Almighty fails to show up? You get chaos. But from that chaos, sometimes you get laws. The legal system is supposed to be a fortress of logic, but every now and then, a lawsuit so profoundly dumb breaks through the walls, forcing society to create a new rule just to make sure it never happens again. We're about to explore the spectacular court cases that created our most absurd laws. 1. We have to start with the Mona Lisa of ridiculous litigation, the $54 million pants. In 2005, a Washington, D.C. judge named Roy Pearson brought his trousers to a local dry cleaner, who then misplaced them. A normal person would be annoyed. Pearson, an administrative law judge, decided this was an offense worthy of a payout that could fund a small country's space program. His logic? The satisfaction guaranteed sign in the window was an unbreakable legal contract worth the GDP of a small island nation. The case dragged on for years, nearly destroying the immigrant family who owned the business. While Pearson ultimately lost, the sheer, weaponized pettiness of it all became a national embarrassment. It forced the legal system to create much stronger, clearer rules against frivolous lawsuits, essentially writing a new law that says, no, you can't sue someone into oblivion over a lost pair of pants. It was a clarification the world desperately needed, especially since the person who needed to hear it most was, ironically, a judge. 2. In 2007, Nebraska State Senator Ernie Chambers decided to aim a little higher. He filed a lawsuit against God. Yes, the actual omnipotent deity. He sought a permanent injunction to stop God from unleashing fearsome floods and horrendous hurricanes. The most incredible part? The court didn't immediately throw it out as the ramblings of a madman. A judge actually heard the case. It was eventually dismissed not on the grounds of being biblically insane, but for a procedural hiccup. God, being ethereal and all, couldn't be physically served a summons. The court couldn't find his address. This created a wild legal precedent in Nebraska. Suing the creator of the universe is theoretically possible, but the case will get stuck in logistical hell. So God remains undefeated in court, not by divine right, but due to a lack of a valid P.O. box. 3. Not to be outdone, an inmate in Virginia named Robert Lee Brock had a brilliant idea. He would sue himself for $5 million. He claimed that by getting drunk and committing crimes, he had violated his own civil rights and religious beliefs. But here was the masterstroke. Since he was in prison and had no income, he demanded the state of Virginia pay the damages to himself. The judge, in a masterclass of judicial restraint, dismissed the case. He pointed out the beautiful, flawless paradox at its heart. This wasn't a lawsuit. It was a philosophical Escher painting. The case is now enshrined in law schools, a perfect illustration of a frivolous claim, legally cementing the rule that you can't use the court system to pull off the world's dumbest financial loop-de-loop. 4. You start to see a pattern here, right? The legal system is constantly being stress-tested by human creativity at its most unhinged. But what happens when that creativity goes international? Well, in 2008, the mayor of a Turkish city named Batman announced his intention to sue Warner Brothers and director Christopher Nolan. He claimed the studio had used the city's name for their The Dark Knight franchise without permission. He went on to allege this caused psychological trauma to residents and a spike in crime, as if the movie's release somehow activated real-life supervillains in his town. The lawsuit was so ridiculous it never even made it to a courtroom, becoming an international punchline overnight. The real legal precedent it set wasn't on the books, but in the court of public opinion. It established the unwritten "Don't Sue Batman" rule, a law of common sense that reminds cities everywhere that picking a legal fight with a beloved multi-billion-dollar franchise is, to put it mildly, a bad idea. 5. In 1997, a psychic sued NASA for $300 million. Her claim was that the Mars Pathfinder rover, which had just landed on the Red Planet, was trespassing. She asserted that she was a Martian ambassador and the cold, sterile machinery was disrupting the planet's delicate vibratory balance, which in turn was messing with her psychic abilities. The case was, of course, dismissed faster than a UFO sighting. But in doing so, the court unofficially established what could be called the extraterrestrial standing doctrine. It confirmed a crucial legal point. To have a valid claim in a U.S. court, you generally need to be from planet Earth. Sorry, Martians, no legal recourse for you. 6. You order a large iced coffee and it's mostly ice. It's an annoyance we've all faced. But for one Chicago woman, it was a federal case. In 2016, she filed a $5 million class action lawsuit against Starbucks for fraud. Her argument was that a 24-ounce venti drink wasn't actually 24 ounces of coffee if half the cup was filled with frozen water. The judge threw it out, dryly observing that a child would know that ice displaces liquid. This case became a key modern example of the reasonable consumer standard, a legal principle that basically says the law isn't designed to protect you from the fundamental laws of physics. 7. Back in the 90s, a man named Richard Overton took Anheuser-Busch to court for $10,000 over their Bud Light commercials. The ads showed guys on a beach, and as soon as they cracked open a beer, beautiful women would magically appear. Overton argued this was blatant false advertising. He had consumed their product, he claimed, yet no tropical fantasies or beautiful women materialized. He sued for emotional distress. The court, unsurprisingly, dismissed the case, solidifying the legal concept of puffery, the idea that fantastical, exaggerated claims in advertising are not meant to be taken as literal fact. This ruling is the reason you can't sue an energy drink company because it failed to give you actual wings. 8. So far, the courts have managed to shut most of this nonsense down. But what do you do when one person just won't stop filing these kinds of cases? California found a solution, a law that allows them to officially label someone a vexatious litigant. This law was born from the costly chaos caused by individuals who clog the court system with hundreds of baseless lawsuits. Once you earn this title, you are legally forbidden from filing any new lawsuits without getting a judge's permission first. The law was famously applied to a man who filed over 300 separate lawsuits stemming from a single minor car accident. He sued everyone from the other driver to the tow truck operator. This isn't just a law, it's a legal restraining order against people who treat the courthouse like their personal playground. 9. A man in Michigan won a Subway for Life contest, then promptly sued the company for his prize. Instead of a magical card granting him infinite sandwiches until his dying breath, he received about $13,000 in gift cards. He argued that for life should mean, well, for life. The resulting court case had to legally define the term lifetime supply. The judge eventually sided with Subway, ruling that companies have the right to define the terms of their own contests. This sensible decision saved us from a world where prize winners could single-handedly bankrupt corporations with an endless, lifelong demand for free sandwiches. 10. Everyone thinks they know the McDonald's hot coffee lawsuit. It's become the go-to example of legal stupidity. But the reality is the polar opposite. In 1992, 79-year-old Stella Liebeck suffered third-degree burns that required skin grafts after spilling McDonald's coffee. The coffee wasn't just hot. It was served at a temperature capable of melting the paint off a car, far hotter than any home coffee machine. It was revealed in court that McDonald's knew about over 700 previous burn incidents and did nothing. The jury's large award wasn't about a simple spill. It was punishment for corporate negligence. But McDonald's launched a massive PR campaign to frame Liebeck as greedy. They won in the court of public opinion, creating a myth that persists today. So the case didn't create a dumb law. It reinforced a vital one about corporate responsibility. But it also created a powerful, cynical playbook on how to manipulate a narrative and convince millions of people that the victim is actually the villain. 11. A few years ago, the internet was blessed with a photo of a grinning macaque who had stolen a photographer's camera and snapped a perfect selfie. It was a funny, viral moment until the lawyers got involved. The animal rights group PETA filed a lawsuit on behalf of the monkey, whom they named Naruto, claiming the monkey owned the copyright to his own photo. This kicked off a bizarre legal battle that went all the way to a federal appeals court. The central question was mind-bending. Can an animal own intellectual property? The court eventually ruled that no, an animal cannot sue for copyright infringement. But the case forced the U.S. Copyright Office to officially update its rules to explicitly state that works created by non-humans, be it a monkey, a ghost, or a divine being, are not protected by law. A monkey's selfie literally rewrote American copyright policy. 12. In 2006, a man from Portland, Oregon named Alan Heckard filed a lawsuit against Michael Jordan and Nike for a staggering $832 million. His reason? He looked too much like Michael Jordan. Heckard claimed the resemblance was so strong that he was constantly being harassed in public, causing him immense emotional pain and suffering. He argued that he couldn't go to the gym, ride the bus, or even attend church without being mistaken for the basketball legend. The lawsuit was eventually dropped, but not before becoming a global laughingstock. It serves as a crucial, albeit hilarious, legal precedent that solidifies the idea that you can't sue someone for having a similar face. Your own likeness, it turns out, isn't a trademark you can defend in court. 13. For decades, kids have been happily eating Froot Loops cereal, blissfully unaware of the shocking truth: there is no actual fruit in it. This revelation was apparently too much for a California man who, in 2009, filed a class action lawsuit against Kellogg's for false advertising. He argued that the name Fruit misleadingly implied the presence of real, healthy fruit. The judge, however, was not impressed. In dismissing the case, she pointed out that the very spelling of fruit was a clear indicator that the product was not a health food. The ruling was another victory for the reasonable consumer standard, legally affirming that the law will not protect you from your own failure to recognize that a rainbow-colored sugar puff called fruit is probably not part of a balanced diet. 14. Now, most of these cases are just dumb. But this next one is dumb on a much darker, more profound level. In 1981, a man named Arne Cheyenne Johnson stabbed his landlord to death. His defense in court was unprecedented. He claimed he wasn't responsible because he was possessed by a demon at the time. His lawyers literally argued in a court of law that the devil made him do it. The judge flatly rejected the argument, stating that such a defense was impossible to prove and had no place in a rational legal system. The ruling established a rock-solid legal precedent. Demonic possession is not a viable insanity defense in the United States. The case drew a permanent line in the sand, separating the laws of man from the lore of the supernatural. 15. When you attend a magic show, you expect illusion. You don't expect to become part of a lawsuit that exposes the entire trick. A British man attending a David Copperfield show in Las Vegas was chosen to participate in an illusion where he and others would seemingly vanish from the stage. During the trick, he was rushed through dark secret corridors where he fell and was seriously injured. He sued. To defend himself, Copperfield's legal team had no choice but to explain, under oath and in excruciating detail, exactly how the famous illusion worked. The magician ultimately won the case, but at a huge cost. The lawsuit forced the magical world's hand, creating a legal precedent on liability for audience participation while simultaneously killing a piece of cherished magic forever by revealing its secret. 16. We've all blamed our parents for something. But a 28-year-old man from New York took it a step further. He sued his parents for $200,000 for malpractice of parenting. He claimed they hadn't loved him enough, had been emotionally unsupportive, and were ultimately responsible for him being unemployed and unhappy as an adult. The court dismissed the lawsuit so fast it barely made a ripple, stating that there is no legal standard for good parenting that can be enforced with a lawsuit. The ruling was a crucial defense of families everywhere, creating a legal firewall that prevents courtrooms from becoming theaters for airing every childhood grievance and perceived parental slight. 17. It's one thing to be annoyed when the weather forecast is wrong. It's another to sue over it. An Israeli woman sued a television station after they predicted a sunny day. and it rained. She claimed that, based on their forecast, she dressed lightly, went outside, caught the flu, missed a week of work, and spent money on medication. The most insane part? She won. The station was ordered to pay her over $1,000 in a settlement. Though it happened outside the US, the case became a global cautionary tale for media outlets. It's the reason weather forecasters today use cautious, probabilistic language like a 40% chance of rain, creating a legal shield to protect them from being held responsible for the inherently unpredictable whims of Mother Nature. 18. Companies are often sued for failure to warn customers about potential dangers. But one lawsuit against BMW took this concept to a whole new level of absurdity. A man was riding his BMW motorcycle, which was equipped with a throttle locking mechanism similar to cruise control. He activated it, then let go of the handlebars to get something from his backpack. He, of course, crashed. He then sued BMW, arguing the company failed to warn him that it was a bad idea to let go of the handlebars of a moving motorcycle. The court threw the case out, but it's a perfect example of why our products are now covered in ridiculously obvious warnings, like the label on an iron that says, "Do not iron clothes while wearing them." 19. If you go to a haunted house, you expect to be scared. But for one woman at Universal Studios, the experience was apparently too authentic. During their Halloween Horror Nights event, she was so frightened by a character jumping out at her that she fainted, fell, and broke her wrist. She then sued Universal, claiming their haunted house was too scary and that they had a duty to not frighten customers to the point of injury. The court sided with the theme park, establishing a powerful precedent based on the legal principle of assumption of risk. In simple terms, the law officially recognizes that the entire point of a haunted house is to be scary, and by buying a ticket, you're agreeing to be scared. You can't sue for getting exactly what you paid for. 20. In 2013, a viral photo showed a Subway foot-long sandwich that was only 11 inches long. The internet erupted in mock outrage, which quickly turned into a very real, very expensive class action lawsuit. The case dragged on for years, with lawyers for both sides racking up millions in fees. And the final settlement? The lead attorneys were awarded over $500,000. The customers who were supposedly cheated out of an inch of sandwich? They got absolutely nothing. The judge himself called the settlement utterly worthless. The case didn't change any laws about sandwich length, but it did become a monumental example of how the class action system can be exploited for the benefit of no one but the lawyers, sparking a serious debate about reforming the entire process. 21. In 1978, a politician named Dan White shot and killed the mayor of San Francisco and supervisor Harvey Milk. The defense his lawyers used would go down in infamy as the Twinkie defense. The media spun it as if his lawyers claimed he was hopped up on sugar and junk food, making him crazy. The reality was more complex. They argued that his sudden switch to a diet of Twinkies and soda was a symptom of a severe depression that led to diminished mental capacity. The jury bought it, convicting him of a lesser charge. The public was absolutely furious. The verdict created such a massive backlash that it led to a new law in California, abolishing the diminished capacity defense. A case that became a national punchline about junk food actually had the profound legal consequence of rewriting the rules for murder trials in the state. 22. In the 90s, Pepsi ran a promotional campaign called Pepsi Stuff, where you could collect points from their products to redeem for prizes. The commercial for the campaign ended with a joke. A kid lands a Harrier jet at his high school with the caption 7,000 Pepsi points. A 21-year-old business student named John Leonard saw this not as a joke, but as an offer. He found a loophole, allowing him to buy points, raise $700,000, and send a check to Pepsi demanding his fighter jet. Pepsi refused, and Leonard sued. The court ultimately sided with Pepsi, ruling that no reasonable person would have believed the ad was a genuine offer for a military aircraft. The case, Leonard vs. PepsiCo, Inc., is now a cornerstone of contract law, a permanent legal reminder that hyperbole in advertising is not, in fact, a legally binding promise to give you a jet. 23. What, legally speaking, is a sandwich? This question seems like a late-night dorm room debate, but in 2006, it was the central issue in a Massachusetts court case. A Panera Bread in a shopping mall had a contract that gave it exclusive rights to sell sandwiches. When a Qdoba restaurant prepared to open, Panera sued, arguing that a burrito is a type of sandwich. What followed was a gloriously absurd legal battle involving dictionary definitions and expert testimony on the nature of bread. The judge ultimately ruled that a burrito is not a sandwich, citing that it is typically eaten with one's hands and contains fillings like rice and beans, which are not traditional sandwich ingredients. This decision created an actual legal precedent that now influences real estate contracts and franchise agreements across the country. 24. In 2021, Mariah Carey's own brother sued her for defamation over passages in her best-selling memoir. He claimed her depiction of him caused immense emotional distress. The case put the very nature of memory and autobiography on trial. Can you be sued for telling your own life story from your own perspective? The judge threw out most of the claims, ruling that Carey's statements were either opinion or presented as personal recollections from her childhood, not as objective facts. The case set a powerful modern precedent, reinforcing the legal protection for memoirists. It affirmed that the law understands that family history isn't a court transcript. It's a collection of personal, often conflicting stories. 25. When hotel magnate Leona Helmsley died in 2007, she left $12 million in her will to her pet Maltese dog, named Trouble. She left nothing to two of her grandchildren. The grandchildren, understandably, sued. The resulting court battle was a media circus that ended with a judge reducing the dog's inheritance to a mere $2 million. But the case's impact was huge. The spectacle of a dog inheriting more than most humans earn in a lifetime popularized a new legal tool: the pet trust. Lawmakers in many states passed new statutes to formally recognize and regulate these trusts, allowing pet owners to legally provide for their animals after they die. A billionaire's absurd love for her dog fundamentally changed American estate law. 26. You've probably heard the story. A burglar breaks into a house, gets injured, and successfully sues the homeowner. While the most famous versions of this are urban legends, they are rooted in a real legal principle that has been tested in court. A homeowner does have some duty of care even to a trespasser. Specifically, you can't set malicious booby traps. Cases where criminals injured themselves and then sued, while rarely successful, caused widespread public fear and outrage. This led to a wave of castle doctrine and make my day laws across the United States. These laws were specifically written to provide homeowners with enhanced legal immunity from lawsuits filed by intruders they injure while defending their property, a direct response to some of the dumbest and most audacious lawsuits imaginable. 27. An urban legend for the ages tells of a man who bought a new Winnebago RV, got on the highway, set the cruise control to 70 miles per hour, and then walked to the back to make a sandwich. The RV, of course, crashed. He then sued Winnebago for not warning him that he couldn't do this. While this specific case is almost certainly not real, it perfectly embodies the pressure that decades of frivolous lawsuits have put on manufacturers. The fear of being the defendant in a case like this is the reason our world is now plastered with painfully obvious warnings. It's why your hairdryer has a tag that says, "Do not use while sleeping." The idea of this lawsuit created a real-world legal strategy of defensive labeling to protect companies from our own worst instincts. 28. Can you own a sound? Harley-Davidson certainly thought so. In 1994, the company filed an application to trademark the unique, syncopated, potato-potato-potato sound of its V-twin engine. They argued the sound was a key part of their brand identity. Their competitors immediately filed legal challenges, kicking off a 6-year legal war over a noise. The case finally ended when Harley-Davidson dropped the application, realizing it was an unwinnable and expensive fight. The attempt, however, forced the U.S. Patent and Trademark Office to clarify its position. A sound that is a functional byproduct of a machine's operation cannot be monopolized. You can't legally own the sound your product makes just by using it, a ruling that has kept our soundscape from being carved up by corporate lawyers. 29. A man named Mark Johnston went on a gambling spree in Las Vegas, losing $500,000 at a casino in a single weekend. A few months later, he sued the casino to get his money back. His argument was that he was a known compulsive gambler and was visibly intoxicated, and therefore the casino had a duty to stop him from betting. The case put a fundamental question before the Nevada Supreme Court. Who is responsible for a person's gambling losses? The court ultimately ruled against Johnston, declaring that casinos do not have a legal duty to save patrons from their own compulsive behavior. This landmark decision sent shockwaves through the industry, setting a powerful precedent that protects casinos from being held financially responsible for the personal demons of their customers. 30. We've already established that Froot Loops don't contain fruit. But what about Cap'n Crunch? In 2009, a California woman sued PepsiCo, the maker of the cereal, claiming she was deceived into believing that crunch berries were real berries. For 4 years, she said, she had been eating them, only to discover the shocking truth that the colorful balls were just sugar and corn. The judge dismissed the case with thinly veiled contempt, stating that the vibrantly colored, uniformly shaped pieces of cereal in no way resemble actual fruit. This case is now a shining example in law textbooks, further cementing the legal doctrine that the law is not there to protect you from a complete and utter lack of common sense. 31. In 2012, a man in Michigan bought a Red Bull. He drank it, and then he didn't grow wings. In fact, he had been drinking it for years and had not once developed the ability to fly or experienced any enhanced physical or intellectual performance. So, he sued Red Bull for false advertising. What could have been an easily dismissed case took a surprising turn. Red Bull, likely wanting to avoid a long and embarrassing public trial, agreed to settle a massive $13 million class action lawsuit. The settlement allowed anyone who had bought a Red Bull in the previous decade to claim either $10 in cash or $15 in Red Bull products. The case established a bizarre precedent. You might not win a lawsuit based on puffery, but if the claim is just specific enough, you might scare a company into paying you to just go away. 32. For over a century, the song Happy Birthday to You was a legal minefield. Warner Chappell Music claimed to own the copyright and aggressively charged thousands of dollars for its use in movies, TV shows, and even at restaurants. In 2013, a documentary filmmaker who was forced to pay a fee decided to fight back. Her lawsuit uncovered a shocking truth. The company's copyright claim was invalid. The original copyright from 1935 only covered a specific piano arrangement, not the song itself. A judge ruled that the song Happy Birthday was and always had been in the public domain. This single lawsuit dismantled a multi-million-dollar corporate monopoly and gave the most famous song in the English language back to the world, for free, forever. 33. A man in New York City named Andrew Rector fell asleep during a baseball game between the Yankees and the Red Sox. An ESPN camera lingered on him, while the commentators made a few lighthearted jokes about him dozing off. Rector was not amused. He sued ESPN, the commentators, and Major League Baseball for $10 million, claiming the broadcast had subjected him to a tsunami of scorn and portrayed him as a fatty, stupid so-and-so. The judge dismissed the case, noting that the commentators' remarks were gentle and, most importantly, Rector was, in fact, asleep. The ruling was a significant victory for live broadcasters, legally affirming their right to comment on events in a crowd without fear of a lawsuit from every person caught on camera in a less than flattering moment. 34. In 2005, a Texas man who had purchased a Dell computer with a service plan sued the company because of the frustrating experience he had with their customer support in India. He didn't just sue for his own troubles. He filed a class action suit on behalf of everyone who had been subjected to Dell's outsourced tech support. The case, Miller v. Dell, became a flashpoint for the debate over globalization and customer service. While the case was eventually settled out of court, it sent a powerful message to corporations. Outsourcing may be cost-effective, but if the quality of service drops too low, it can create a massive legal and financial liability. It was a lawsuit that put the entire practice of offshore customer support on trial. 35. What happens when a TV weather girl's joke goes wrong? A woman from San Diego was watching the local news when the forecaster, trying to be funny, showed a picture of a gorilla and said it was a photo of the plaintiff, who had been repeatedly emailing the station. The woman sued for defamation. The station argued it was a harmless joke. The court disagreed, ruling that even a joke can be defamatory if it holds someone up to public ridicule. The woman was awarded $500,000. The case drew a clear legal line in the sand for media personalities, establishing that you can't just call someone a gorilla on television and then hide behind the defense that you were just kidding. 36. The band Creed, famous for their brand of post-grunge rock, was sued by 4 of their own fans after a concert in Chicago. The fans claimed the band's lead singer, Scott Stapp, was so intoxicated that he was unable to sing the lyrics of a single Creed song and just mumbled and rolled around on the floor. They demanded a full refund for their tickets, arguing the performance was so bad it didn't even legally qualify as a concert. The court ultimately dismissed the case, but it raised a fascinating legal question. Is there a minimum standard of quality for a live performance? The ruling implicitly suggested that no, there isn't. When you buy a ticket, you're paying for the chance to see a good show, not a guarantee. 37. In 2000, an advertising executive created a series of commercials for his own company featuring a sock puppet. The ads were a huge success, so much so that PetSmart launched its own ad campaign featuring a sock puppet mascot for their brand. The ad exec sued PetSmart for stealing his idea. The court had to grapple with a tricky legal question. Can you copyright the idea of a sock puppet? The judge ruled that you can't. The idea of using a sock puppet is too generic to be owned by one person. This case, and others like it, helped to define the limits of intellectual property law. It established that you can copyright a specific character, but you can't monopolize an entire archetype, ensuring our culture doesn't become a legal battlefield where someone can sue you for writing a story about a vampire or a wizard. 38. A man in Brazil was having an affair. His wife found out and sued the mistress for moral damages, claiming the affair had caused her profound emotional suffering and destroyed her family. In a shocking decision, the Brazilian court agreed, ordering the mistress to pay the wife the equivalent of over $60,000. While this wasn't a U.S. case, it created a global legal discussion. In America, similar alienation of affection lawsuits were once common, but have now been abolished in all but a few states. The Brazilian case served as a stark reminder of a different legal path, one where courts can be used to seek financial retribution, not just for physical or financial harm, but for a broken heart. 39. A prisoner serving a life sentence in Colorado sued the National Football League for $100 million. His claim? The NFL's referees had made a bad call during a playoff game that cost the Dallas Cowboys a victory. He argued that as a lifelong Cowboys fan, the unjust ruling caused him severe emotional distress. The lawsuit was quickly dismissed as frivolous, but it's a perfect encapsulation of how deeply sports and law can collide. The ruling reinforced the legal principle that you can't sue over a game's outcome. Courts have consistently refused to become a replay booth, legally establishing that a referee's bad call, no matter how infuriating, is not grounds for a lawsuit. 40. In 2014, a woman in Los Angeles sued the makers of the lip balm brand EOS. She claimed the product caused her lips to blister, crack, and rash, and filed a class action lawsuit that quickly went viral, causing a panic among the brand's millions of customers. The company fought back, releasing data showing their product was safe and hypoallergenic. The lawsuit was eventually settled, with the woman dropping her case. But the damage was done. The case became a textbook example of trial by social media, where an unproven legal accusation can inflict massive reputational and financial damage on a company long before a judge ever hears the evidence. It highlighted a new legal reality where the court of public opinion can be far more powerful and far more chaotic than a court of law. 41. In the early days of the internet, a company named The Knot became the go-to website for wedding planning. Another company, trying to cash in on their success, launched a site called The Butt, using a similar design and font. The Knot sued them for trademark infringement. The case became a hilarious lesson in branding law, with lawyers seriously debating the similarities between knots and butts in a federal courtroom. The judge eventually ruled in favor of The Knot, granting an injunction to shut down The Butt. The ruling was a classic application of trademark law, affirming that you can't create a parody brand that is so similar to the original that it confuses consumers, no matter how funny the parody might be. 42. When the film Drive was released, its trailer promised a high-octane, car chase-filled action movie in the vein of Fast and Furious. The actual film was a slow-burn, atmospheric, and often brutally violent art house thriller. A woman in Michigan was so disappointed by this that she sued the film distributor, claiming the trailer was misleading advertising. The court dismissed the case, but it sparked a serious debate. The ruling established that movie trailers are considered artistic works in themselves and are allowed a certain amount of creative leeway. They don't have to be a literal, scene-by-scene summary of the final film, legally protecting the art of the movie trailer from being regulated like an ad for a toaster. 43. A woman was fired from her job at a Procter & Gamble subsidiary. She then sued her former employer, claiming she was terminated because her boss couldn't stand the smell of her body odor, which she said was caused by a medical condition. The lawsuit tested the limits of the Americans with Disabilities Act. Does protection against discrimination extend to an employee's offensive smell? The court ultimately sided with the employer, ruling that while the ADA requires reasonable accommodations for disabilities, it does not require a company to tolerate an employee's odor if it is disruptive to the workplace. The decision drew a difficult but important line, defining where the rights of one employee meet the rights of their coworkers. 44. In 2007, a man named Jonathan Lee Riches, then an inmate in federal prison, filed what is likely the most ambitious lawsuit in human history. He sued the Guinness Book of World Records for $5 million, claiming they had no right to name another man, the world's most litigious man, a title he felt he deserved. He had, after all, filed thousands of lawsuits against everyone from Plato and Nostradamus to the Eiffel Tower and the Holy Grail. The court dismissed the case, but the sheer audacity of it all is a monument to legal absurdity. It's a lawsuit that perfectly embodies the problem of frivolous litigation. A man suing a book for not recognizing his achievement of filing too many lawsuits. 45. A man from Pennsylvania sued the magician David Blaine for over $2 million. He wasn't injured, and he didn't participate in a trick. He sued because he believed David Blaine was a sorcerer using witchcraft to defy the laws of physics, and was therefore an agent of Satan. He claimed Blaine's magic was real and that he was stealing his God-given powers. The court, to absolutely no one's surprise, threw the case out. This bizarre lawsuit stands as a modern-day witch trial, a legal precedent that, while completely unnecessary, officially confirms that you cannot sue someone in a U.S. court for being a wizard. 46. A student at the University of Nebraska sued the university's dean and the entire Board of Regents for discriminating against all followers of Pastafarianism. For the uninitiated, that's the Church of the Flying Spaghetti Monster, a satirical religion created to protest the teaching of creationism in schools. The student argued that as a devout Pastafarian, he had a right to wear a pirate colander on his head in his driver's license photo, a right the university was denying him on his student ID. The court dismissed his case, ruling that Pastafarianism, while a brilliant piece of satire, does not qualify as a real religion deserving of legal protection. The ruling legally defined the difference between a sincere faith and a really good joke. 47. A woman in New York filed a lawsuit against the makers of Nutella. She claimed she had been feeding it to her children for years under the impression that it was a healthy, nutritious part of a balanced breakfast, thanks to commercials that highlighted ingredients like skim milk and hazelnuts. She was shocked to discover it was, in fact, a sugary dessert spread. The company, Ferrero, chose to settle the case for $3 million, offering refunds to customers. The settlement sent a clear message to food companies. You can't just highlight the healthy-sounding ingredients in your marketing while conveniently ignoring the mountain of sugar and fat. It was a major victory in the legal battle over what constitutes healthy in food advertising. 48. In 2009, a woman named Katharina Katina sued her neighbor for $1.5 million because his parrot was allegedly sexually harassing her. She claimed the parrot, named Charlie, would repeatedly shout obscene and insulting phrases at her whenever she was in her backyard. The neighbor insisted the parrot was just mimicking things he heard on television. The case was eventually dropped, but not before becoming an international media sensation. It serves as a hilarious, if strange, example of how even the most bizarre neighborly disputes can end up in the legal system, forcing judges to contemplate questions they never thought they'd face, like whether a bird can be held legally responsible for its foul mouth. 49. A man in California sued the city of San Diego after he was given a ticket for not wearing a seatbelt on his horse. He was riding his horse in a protest parade when a police officer cited him, claiming that under California law, a horse could be considered a vehicle. The man fought the ticket in court. The judge, with what must have been an incredible straight face, sided with the horseman, ruling that for the purposes of the seatbelt law, a horse is not, in fact, a vehicle. The case forced the state to clarify its vehicle code, ensuring that no other equestrian would ever have to face the absurd prospect of trying to buckle up a 1,000-pound animal. All right, 49 cases down, 1 to go. But before our final exhibit, it's time for the final verdict. The award for the dumbest case that created the most consequential law for the advertising world goes to the man who sued Pepsi for a Harrier jet. Why this one? Because it's the perfect collision of youthful audacity and corporate hyperbole. A kid saw a joke in a commercial and called the company's bluff with $700,000. The resulting lawsuit forced the legal system to draw a permanent, crystal-clear line in the sand, creating the definitive legal precedent that says an obviously ridiculous joke in an ad is not a legally binding contract. Every over-the-top commercial you see today is protected by the ghost of that lawsuit. Do you agree? Let us know your pick in the comments. And now, for our final number. 50. The case that gave us the most important dumb law of the internet age is arguably Blumenthal versus Drudge. In the late 90s, the gossip site The Drudge Report ran a story falsely accusing a White House aide of spousal abuse. The aide sued not just Matt Drudge, but also America Online, the internet service provider that hosted the report. This was a critical moment. If AOL was held liable, it would have meant that every ISP, every forum, every website would be legally responsible for everything their users posted. It would have killed the internet as we know it. The court ruled in favor of AOL, a decision that became the foundation for Section 230 of the Communications Decency Act. This is the law that says online platforms aren't liable for what their users post. It's the bedrock of the modern internet, the reason YouTube, Facebook, and Twitter can even exist. And it was all born from a dumb, false piece of gossip. So, from lawsuits against God to legal battles over sandwiches, it's clear that the path of the law is not always straight. It's a messy, chaotic, and often hilarious reflection of our own absurdity. These cases aren't just funny stories. They are the stress tests that bend, break, and ultimately shape the rules that govern our lives. What is the most ridiculous lawsuit you've ever heard of that we missed? Share your favorite examples in the comments below, because the rabbit hole of legal insanity goes deeper than you can possibly imagine. And if you enjoyed this journey into the bizarre, make sure to subscribe and turn on notifications so you don't miss our next exploration of the world's most fascinating stories.